Hello, and thank you for joining us at Blueprint Legal Seminars. Our speaker today will be Robbie Sufi, former large law firm lawyer, adjunct professor of law, and currently the managing attorney at Axis Legal Counsel. After the seminar is over, please follow the links to request California MCLE credit and evaluate the seminar. If you have any questions about the seminar, feel free to send us an email and we'll get it answered for you.
Okay, well, hello and welcome everybody. Thanks for joining us today for the seminar that's entitled From Good to Outstanding Advanced Legal Research. I'm your host, Robbie Sufi. Okay, so let's just go ahead and get started with today's presentation. By the way, make a note that during the presentation, Blueprint Legal will have 2 codes on the screen to verify that you've been attending. And I believe you've got to make a note of it, and then when the seminar is over, to request CLE credit, you'll have to input those codes in on the link that you have been sent. So just don't forget to do that. Okay, so starting off, why is legal research training important? You probably already know that legal research is one of the high areas where there's write-offs of associate time. You know, write-offs are not good for anybody. They're not good for the firm because, you know, the firm isn't making money. But obviously, from an associate standpoint, they're not helpful because they affect things like realization ratios and your overall perception of being, you know, how effective you are being perceived as being when doing legal work for clients. Law school does not do a fantastic job of training associates, especially in complex litigation cases, for effective legal research. You know, you're kind of given this, you know, free rein to do as much research as you need to get to the right answer. And unfortunately, that isn't always possible. It teaches bad habits because you usually don't have that kind of time, and the client certainly doesn't have the kind of money to embark on this adventure to figure out the right answer. So it's really, really important to have a plan when you're doing legal research. And unfortunately, in the law firm setting, whether you're, you know, a clerk, a junior associate, or in the mid-level moving up to being a senior associate, the law firms don't really teach you how to do legal research. You're just kind of expected to know how to do it. And if you don't know how to do it, you're dinged for not knowing how to do it. And, you know, there's really very minimal mentorship and very minimal training in this area. So it's an easy place to get tripped up. And it just results in whoever you're being given the assignment from being disappointed with the results, which is not good, again, for anybody. So the goals of the training today are to help you in your mind think about how you're going to be researching, how to research effectively, how to research efficiently, how to get the right answers without spinning your wheels. Another mistake that tends to happen is when people just find authority that is either not persuasive, not helpful, and then if you get called out on just inserting string citations that have no relevance to the legal issue, it just makes you look like you haven't done a good job at it. So the point of all this is how to get to a place where you're providing useful legal research with minimal redos, and you're not, getting accused of not doing a good job on legal research projects. Okay. So let's start off with this. To research effectively, you really have to think of when you're going to be doing the legal research and why you're going to be doing it, because the type of legal research you're going to be doing is going to change depending on the purpose of it. For example, if you're doing legal research for pre-suit matters, let's say you've gotten a demand from plaintiff's counsel or defense counsel or counterclaimants counsel, and you're responding to it, or let's say there's discovery, meet and confer letters or opinion letters to clients. These are kind of require obviously a less stringent kind of legal research. You don't have to run down every fact pattern, figure out what the procedural posture is or the holding is of decisions. You can be a little bit looser because it's obviously not as big of a deal. On the other hand, you might be doing legal research in making allegations to a complaint, filing a demur or motion to dismiss or an MSJ, and the kind of legal research you do, where you do the legal research is going to change. All right. During litigation, legal research can help you figure out what claims you're supposed to be making if you're representing a claimant. On the other hand, if you're challenging a claimant's claims, it can help you, ding out what elements of their claim they have not made. Doing legal research when it comes to discovery can be really helpful because you could, let's say you've got some fact pattern that lends itself very well to an MSJ. If you know what the judges and courts look for when analyzing whether to grant summary judgment, you can then work it into your discovery and contention interrogatories to really, narrow down the other side and pin them down as to what they're alleging and what they're not. All right? Okay, you all know this stuff. Westlaw, Lexis, Rudder, CEB, others. A lot of, I don't know if people are still insisting that you start off with print resources. It's really, really time consuming, picking through print resources. The electronic way is much faster. However, it can be more expensive. That's why people, always insist that you start off with the written materials like those, massive Rudder multi-volume sets where, you just spend half hour to an hour reading to find the point that you're trying to make. Okay, so the first course participation code we've come upon is 25981, 25981. Just please make a note of it. And let's move on. So let's say you get your assignment, where to begin. Doing legal research is like diving into this ocean where you really don't know where the treasure is. I mean, when you're looking up at the top, it doesn't look like there's anything in the bottom. You don't really know where to begin. You don't really know where to go. And all you can do is just kind of dive in and try to find what you're looking for. If you look at the next graphic, it kind of helps demonstrate, that it's not always easy to figure out where the treasure is. There's lots of sharks swimming around. You could get distracted. So here's some tips on, where to begin. Number one, resist the temptation to begin researching immediately. It's really easy to just want to dive right in and start kind of, looking by looking, searching by looking. However, that can be very, very ineffective, and it can rack up a lot of time and money, especially on legal research fees, because you're not sure what you're looking for. So the lesson here is take time to develop a plan. If you put together a plan of what you're looking for, where it could possibly be found, and how to get it, you will almost always avoid excessive research, inefficient research, and roads to nowhere that lead you to a place where you're just spinning your wheels. If the plan that you've put together fails, at least you've got the safety mechanism so you can return to the attorney who's assigned the project for more help. This kind of gets away from the problem that sometimes associates have where the partner that's assigning the work gets mad at them for not checking in often enough and, spending too much time going out too far without coming back and saying, am I on the right track? Okay? All right, so let's talk about developing this plan and how you would actually go about doing it. All right. First thing, why are you researching? What is the point of it? Number two, the landscape. Where is what you're looking for going to be found? Number three, what kind of research and what kind of answers are you going to need depending on what stage of the litigation you're in? And number four, how are you going to find what you're looking for? It's an issue of semantics. We're going to go through each of these and drill down in greater detail over the course of the presentation. All right, so starting off in developing a plan, why are you researching what you're researching? The method that you're going to use to research is going to depend on the purpose of your research. For example, are you going to be researching to confirm something the attorney already wants to argue but doesn't have a citation for? Common assignments will be like this. Go find me a case that says that if you're removing to federal court and the defendant is an LLC, that you have to notify all the members of the LLC and get their approval before you can actually remove, because removal requires the consent of all the defendants. So these start off with, go find me a case that says X. The partner or the attorney giving the assignment already knows what they want to argue. They just don't have the citation for it, and they just want you to go find the citation. These are the easiest kinds of legal research projects because you know what you're looking for. Number two, the inquisitive legal research project. what is the answer of XYZ? For example, let me give you an example. Is there a physician-patient privilege when a individual goes to a minute clinic? You know, these clinics at like Target or CVS or Rite Aid, where you walk in and there's a person there that takes your temperature and gives you a flu shot. Does the physician-patient privilege extend to that individual? Do they count as a physician? That would be a inquisitive type research project. The attorney does not know the answer. You have the issue framed in your mind, and they have the issue framed in terms of what you're supposed to be looking for, and your job is to go and find the answer. Okay? Some other types of research projects, burden of proof, standard of review. How are courts supposed to analyze the legal issue? Are the questions jurisdictional? Are they not jurisdictional? If something is resolvable as a matter of law or a fact inquiry. So, for example, let's say you have a declaratory judgment action involving a contract, and the attorney's asking you to find out whether the issue can be decided on an MSJ. These are more procedural kinds of issues, like letters getting lost in the mail, no proof of service, mail rule, delivery rules, issues involving rules of court, the California civil procedures, anything that involves like a procedural matter. Those are kind of like, that kind of question. All right. Then we've got substantive legal research projects where you're looking for, let's say someone on the other side has filed a lawsuit and they have asserted intentional interference with a prospective economic advantage. The substantive legal research project is going to be, go find us the elements to this claim so that we can figure out whether a demur is appropriate. All right. These involve finding rules, finding elements, balancing tests, bright line tests, multi-factor tests. For example, tell us, the standard on which deliberate indifference equals a constitutional violation, or tell us what are the 9 factors that result in an employee being considered an independent contractor versus an employee. Those projects are largely involve case law, and you're going to be, again, finding the answers by looking for elements, tests, and substantive analysis of a particular legal issue. All right? Then we've got, by the way, all of these are presented in terms of like how complex and convoluted the legal research project is. So now we're moving on to interpretive legal projects. This is the kind of legal research project where the attorney has a set of facts and they just don't know whether it fits into certain law or not. Let me give you an example. That independent contractor example I gave. Let's say in your case, you've got an individual who worked at the employer's facility but was given 1099s, and their method of performing the work was very controlled, but they brought their own tools and equipment. The research project might be, analyze this fact pattern in using the background and the legal backdrop of this area of the law. So in this kind of a legal research project, you would be taking your facts, surveying basically all the cases in this particular line of cases, let's say independent contractor / employee law, misclassification law in California. You would read all the cases and you would be comparing them to what your facts are in your case, comparing and contrasting. So in your memo, for example, you would say, in California, the law of independent contractors is XYZ, and you'd go through each of the legal points, and then you'd do this analysis section where you would say, in our case, this is the situation. Like such and such case, it's like this. Unlike this and that case, it's not like this. And so that kind of reasoning and interpretation is intended to give, usually, your client, not your firm or your partner or you. Usually these memos are intended to give to the client to help analyze their risk. All right? Finally, we've got information gathering kind of legal research projects. These usually begin with the attorney saying, find me all the cases that do XYZ. These tend to be like 50-state surveys or, a survey of California law, like what is the law? Or if you're doing searches for, specific background information from the Secretary of State, entity research, you're not really analyzing anything. You're not looking for elements. You're not looking for how courts deal with something. You're putting together a summary of what the law is, and you're just digesting it and feeding it back to the person. It's like treatises. You know how when you read treatises like Rudder or CEBs, they have like, this is what the law is on this particular area of law, and they just, go from one point to another. That's what this kind of legal project is. All right. Okay, moving on. So figure out why you're doing the project and what the project is intended to accomplish. This will help you get to the right answer. If you can fit it into what kind of a legal project is this, you'll be much better off because you'll know what the answer is going to look like. It's like, starting off, it's like cooking. You know how when you cook, you know what your end result is going to be. You want Italian or Chinese or Japanese or Middle Eastern, or let's say you want any kind of food. If you know what cuisine you're going for, you're going to know what ingredients to begin looking for. Like if you're going to make an Italian dish, chances are you're going to be using tomato. If you are going to have something other than Italian, you're not going to have to go to the store and buy tomatoes. Same kind of concept, all right? Okay, moving on. The landscape of who and where. This point is intended to address where the answer to your question is going to lie. For example, if your question is if your question is in response to an information gathering legal research project, for example, summarize California privacy law. You are not going to go into case law for that. You're going to go to statutes because that's a statutory question. So common issues come up is, where is your law going to be located? Is the answer to your question going to be something that arises out of statutory law? Is it something that is going to involve municipal or city, county ordinances? These come up in like nuisance or real estate cases, for example, when people have questions about title disputes or boundary disputes. You always have to go back and look at what the ordinance says. Zoning is also a big city-county issue. Is it an administrative matter? Does it depend on what lower ranking administrative agencies have to follow and what procedures they have to follow? This is big in labor, wage and hour, employee union, collective bargaining agreement type of cases, where to get to a place where you're able to review it from a judicial standpoint, you have to know what the underlying administrative procedures are and how they deal with the issue. All right. Regulatory, healthcare, financial markets, securities work, corporate law. These are all areas where there's a heavy regulatory scheme. By regulatory scheme, I mean there are statutes that enable agencies to enact rules and regulations that govern the particular matter. Let me give you a classic example. Graham Bleach Bliley for financial protections of financial information. If you had a case that involved researching the protections afforded to financial information belonging to consumers and businesses, it would be a tremendous mistake for you to start looking in case law for this information because it's mostly regulatory in nature. Judicial refers to cases. When you're dealing with legal research projects that are going to trigger case law, you've got to think about at what level of judicial authority are the answers going to be found. It is impossible, almost impossible, finding judicial authority that deals with discovery. Why? Because discovery disputes are rarely escalated to Court of Appeals decisions or California Supreme Court decisions. So there's a dearth of authority on specific discovery issues. You'll have the old cases, you'll have like general propositions, but in terms of substantive law versus discovery issues, there's a much greater fund of decisions and authority that deal with substantive areas of the law rather than discovery. Evidence is another big area. It can be really tough to find specific cases on specific evidentiary issues because, again, these cases don't make it up to a level where you get lots of published opinions based on, depending on, whether the issue is heavily dealt with at the trial court level or whether it is an issue that's escalated up for judicial resolution in courts of appeal and the Supreme Court. That is going to affect how many decisions and the level of specificity and detail of the decisions that you're going to be finding. Okay? Same thing with the code, rules of court, local rules, judges' rules. All right, you're going to have to figure out where to begin looking, and you're going to develop the expertise over time. I mean, as time goes on, you'll just eventually get a handle on where should I be looking for this. Giving you, a real life example, it's like going to your kitchen and trying to find dishes versus glasses versus cleaning supplies versus, anything else. Everything has a cabinet. Everything's in its own cabinet. And if you aren't familiar with the kitchen, you're not going to know where to look for a fork or for, Windex. You have to know the lay of the land to know where to look for a particular piece of authority. All right. Okay. We're on another participation code slide. 84547. Just make a note of it. All right. Okay, so going back to landscape issues, it's impossible to overestimate and overemphasize how important non-judicial authority is. By non-judicial authority, I'm referring to civil code, code of civil procedure, government code, corporate code, rules of court, local rules, judges' rules. Law school, unfortunately, again, overwhelmingly focuses on useless things like the ALR, which nobody uses. It's not persuasive authority, and it has no impact or effect on California, legal research because nobody cites national sources. You're looking for mandatory, precedential, binding authority, and that is often statutory. All right. Most sources of law are not judicial in nature. Code, agency rules, regulatory, administrative rules and regulations, letter rulings, administrative orders, all of these things are non-judicial in nature, and California tends to be conservative in terms of making new law that is not interpretive in nature. So if there's code sections, the judicial system here in California is all over the place in terms of how they interpret those rules, but California courts tend to be rather conservative in just making things up. Okay, so how do you kind of get to a place where you know where to look at? You're going to have to take the time to figure your practice area out. If you're in, let's say, environmental law, your landscape is going to be heavily federal in nature, statutory in nature. On the other hand, if your practice area is product liability, you're going to have a warranty law, state statute, judicial authority, and then you're going to have like jurisdictional questions because, in your practice area, there's lots of issues that come up over stream of commerce and, international importers and distributors and retailers versus putting products in streams of commerce. So there's no one size fits all answer in terms of how you figure out where to look for your practice area. The easiest areas are, the trial group type cases, insurance defense cases that are, a couple $100,000 or less in value. Then there's other areas of laws that are really, really convoluted, wage and hour, labor, the hundreds of, laws and regulations that govern how employees are to be treated. So depending on what your practice area is, you may have your work cut out for you more or less than others that are, in different fields. But, you've got to take time, on a professional development basis to get a lay of the land, learn your practice area, and then develop a checklist of what sources are applicable for you given your area of focus. The more you become familiar with the California Code and the code sections, the organization, enabling statutes, it's just going to make you unstoppable in terms of knowing your field and knowing your area. The law profession is a profession of, it doesn't require genius. It doesn't require, you obviously you have to be intelligent, but it doesn't require you to be a gifted human being in order to be successful. It's fortunately a profession where 90% of the success, maybe even 95, comes from just hard work and being organized and doing the work. And if you are obviously serious about, wanting to be in your field and being fantastic at what you do, you owe it to yourself to get to know your area as best you can, and you're just going to shine. People who know their field and are able to remember the rules, remember the law, and answer questions that come up off the top of their head, and even educate judges. You'd be surprised at how little judges tend to know about the more nuanced areas of the law. If you're a person who, really knows the lay of the land really well, you're just going to shine. It's very, very impressive seeing lawyers who have a fluency with their industry and area of law, and they just clearly know what they're doing. And the sooner you get to that place where you're a master of your craft, the more serious you're going to be perceived, by anybody who is looking at you or working with you. All right. Moving on. Okay, so next point is, at what stage are you going to be, are your decisions going to be found? Okay, so this question is focused on when in the life cycle of a litigation is your issue going to be decided. Is it something that's decided on demur, for example, the elements to a claim? Is it something that is to be decided on summary judgment, which is what kind of facts equal a claim that can be resolved through summary judgment or not? Or is it something that is evidentiary in nature, it's decided after a trial takes place? Is it something that involves judicial discretion? These are all very important questions because they're going to affect the strength of your case, okay? And I'll explain a little further as we go on. So you already know the key stages: the demur motion to dismiss stage, dispositive motion stage, trial, post-trial, and appeals. As I said in my in one of the earlier slides, discovery, evidentiary matters, these tend to be difficult to find very specific judicial authority in because, there's less of it at the appeal and publication level. These things tend to be decided by the trial courts, and they never become issues, as the case goes on. All right, so let's go through what each of these stages of litigation, what it can offer you. If you're researching a situation where you're being asked to demur or file a motion to dismiss to a particular claim, you should be looking for cases that are decided on a motion to dismiss. If you're citing a case that has been decided at the trial level or after trial or in the post-trial stage, and you're using it for the proposition that the claim should be dismissed on demur, you're not going to win. It's not going to be effective because you're citing a case that is specifically contrary to the procedural posture of your particular case. So let me give you an example. Let's say a plaintiff files a lawsuit and they allege, conspiracy, all right? And you want to attack the claim and argue that they haven't. You know what? Let's use this. Let's use fraud, because fraud is a great example for this. Assume that the plaintiff uses raises a claim of fraud, and you want to file a demur motion to dismiss, challenging the fraud claim on the basis that sufficient specificity was not provided. They didn't provide the who, what, where, when, how, and why of how the fraudulent misrepresentation was actually made. If you are looking for a case that was decided at the trial level, meaning the underlying party filed a demur and lost, they filed a motion to dismiss and lost, they filed an MSJ and lost, and then the issue was finally decided on trial, if you cite that case, your opposing party is going to be able to use that case right against you, because they're going to use it for the proposition that the very case you are citing does not support the argument you're making, which is this case should be resolved through a demur. So pay very, very close attention to the procedural posture of the case that you're citing. There's some cases there's some instances, I should say, where you can use how a case was decided or how it ended as authority for what you're trying to accomplish itself. So for example, let's go back to the fraud example. let's say the other side files a fraud claim, you file a demur, and you just can't find a case that says failing to include the how and why and who said and when of a fraud claim is subject to dismissal. Let's say you can't find a case that says that language. That does not mean you can't make that same exact argument inferentially. And this is what I mean by that. If you find a case where in the analysis section, so not in the legal section, you know how when you read a case there's the facts and then there's like the law with all the citations and, you know, rules, and then there's a section below where the court kind of delves into it and analyzes it. Just because you can't find in the law section a proposition that stands for what you need does not mean that you can't read through the facts of the case, and if it is a case that decides a fraud claim on a demur and that case was dismissed, meaning that claimant's claims were dismissed, then you can cite that case and in the parentheses put dismissing a plaintiff's fraud claim for failure to include the who, when, why, how of asserting fraud. So there are ways of using cases to make your point at different stages of litigation, even though you can't find something that says it exactly on point. All right? At the dispositive motion stage, this is where you're really looking for an interpretation. So no one disputes the law on independent contractors, for example. If you are an individual who you submit a vendor invoice to the principal, who's the employer. The employer doesn't dictate, you know, when you show up or what you do, and doesn't control how you do what you do, and you supply your own equipment, you work at your own workplace. You have pretty much an independent contractor relationship, okay? That's the law. Nobody disputes the law. The question is, based on the facts of your specific case, can you fit it into the independent contractor puzzle piece, or does it look more like the employee puzzle piece? So you have like, you know, puzzle pieces, and you've got the rules, which are the puzzle, and you're just going to be taking one puzzle piece and fitting it and seeing if it fits. Does it fit in here or does it fit somewhere else? That's the process by which interpretive legal research projects take form, and these are often decided at the dispositive motion stage. Again, nobody disputes the facts, nobody disputes the law. The question is, does this fact equal X or Y? If I tell a nurse at a Minute Clinic my, you know, medical history, is that protected by the physician-patient privilege? Who knows? The judge will decide, yes or no. But those are the kinds of questions that you're going to get in cases that were decided on a dispositive motion. All right. At the trial and post-trial stage, this is going to be largely an area where if jury instructions were issued, if there were improper evidentiary matters, I have found historically that cases decided on trial, post-trial are very, very difficult, I think, to use in briefing because, you know, so much has happened. I find them difficult to use when opposing demurs and MSJs because, as I said, the case has already been to trial. Nothing would go to trial if it was demurred or if it was successful on a dispositive motion. So if you're getting legal authority in cases that have been decided after a trial, it necessarily means that the demur was unsuccessful, and it necessarily means the MSJ was unsuccessful. So those are typically not good cases from a defense perspective. All right. Okay, moving on. So you have developed a plan. You've figured out where on earth to look for the kind of legal research you're going to be looking for. You have thought about at what stage of the litigation the answer to your question is usually decided. That gets us to how the hell do you find what you're looking for and what words do you use. I think this is the single biggest difficulty that junior and mid-level lawyers have in finding answers is because the way that you might think about a question and the way that you might in your mind phrase what the answer might be or what the issue might be is completely different than how it is addressed legally or how courts term it or what phraseology is used, because, you know, things are dealt with using legal terms of art, and if you're not familiar with those legal terms of art, then you're going to have a very difficult time finding whatever the issue is that you're looking for. Let me try to think of an example where word choice is really, really important. You know what's a good area? Prevailing party provisions. You know what I'm talking about. The provision in agreements where if whoever loses has to pay attorney's fees. Okay? It's called a prevailing party provision. That's what it's commonly known as. If you just had no exposure to that term and didn't know what it was, and your supervising partner assigning the project said to you, I need you to find a case, I need you to find instances where attorney's fees are permissible to be requested in a UCL case. All right? So let's say you have a UCL unfair competition law case, and for some reason somebody you're working with wants to know, can we request attorney's fees? If you just did a search, let's say you did a search for this, requesting attorney's fees UCL, you're not going to find anything. It's because nobody talks about it in those terms. Nobody uses that terminology. So the point of all this is you've got to, again, know the lay of the land. You've got to know what you're looking for before you can find it. Otherwise, you're going to have a really hard time finding it. So how do you fix this? West is pretty good with the key number system where they assign, topics. They kind of organize all of law according to, chapters and indexes. And that way, that takes a lot of the ambiguity out of it. You remember that graphic up at the beginning of the presentation where, it was just this view of an ocean from above where it's too opaque to see what's below the surface? The good thing about having indexes, and whether it's the key number system or rudder guides or CEB indexes and outlines and topic systems are fantastic because they kind of show you how, people who've been doing this forever, how they look at the law and where they go for answers. When you're just starting out, or whether you've been doing this for 4 or 5 years, it's still hard to kind of get, like a good pulse on where to look for answers and how to organize in your mind, where the answers are going to be. So having an index is like having just a roadmap. It's really, really valuable. And the better you get to know it, the better you get to know the areas of law in your particular field, the better off you're going to be. All right. So let's now talk about issues of semantics and how to term legal research pursuits to be effective. There are some special issues in this area of law which are, how things change over time and how things are dealt with and how phrases are referred to by lawyers and judges as time goes on. Let me give you a classic example. There's something in the field of insurance law called mending the hold. It's an old term that arises out of like wrestling terminology. And it was a term that's used when like an insurance company just keeps changing its defense as to why it doesn't want to pay. This is a concept in insurance coverage law. I'm not sure if anybody does this area of law who's listening to the seminar. So there's a term like when an insurance company doesn't want to pay, they deny coverage, and they are just changing and changing. Like they'll say, we are denying coverage because of XYZ, and then the policyholder proves them wrong. And then the insurance company is like, okay, well, we're now going to deny coverage on the basis of 1, 2, 3. And if they keep doing that a few times, that concept is called mending the hold. That was a very, very important doctrine 50 to 100 years ago. There's a lot of literature on that a while ago. These days, people don't use it as much. It's called something else. It's called bad faith. And so you pay attention to how concepts just change over time based on, changes in the law, changes in statute, changes in public perception, changes in attitude. You may have an issue, and when you look for it, you may only find 10 to 15 years of cases. It probably means that the law handled it differently earlier than that, and the cases that you're looking for simply aren't coming up because it was dealt with differently. This also happens a lot with statutes. If you're looking for interpretation of a statute and how the statute has been interpreted, if your statute has recently changed, which happens like every year in California, people rewrite all the laws in a particular practice area, and they have all new code sections, and none of the old code sections match up with the previously used ones because all those are repealed. This happens a lot, and so what you're going to have to do is track back all the earlier iterations of that code section and also do legal researches and search terms based on the previous code sections to make sure you're capturing all the relevant authority. Westlaw doesn't do that, and Lexis doesn't do that. They do not match up for you prior code sections of the same law. That's something you'll have to do on your own. All right. And then the other special issue in this area is judges messing things up. Depending on how judges handle specific terms, they may be referring to doctrines and concepts completely different. The concept of estoppel is fantastic. There's different kinds of estoppel: judicial estoppel, equitable estoppel, implied estoppel, collateral estoppel. The problem is judges are not always specific. Sometimes when the research lawyers that work in the courts write these opinions, they're not always specific about what they're referring to, and as a result, you get a collapsing of the distinctions between legal concepts that are discrete, and yet because not enough specificity is provided, they all become the same thing. They're all just referred to as estoppel when they really, in fact, deal with completely different concepts. And so, unfortunately, what this does is it creates a situation where you're forced to spend a lot of time and effort, reading the cases to figure out what on earth they're talking about. Finally, there is an issue with judges who just have very specific preferences. Especially, this happens a lot at the Court of Appeal and Supreme Court level. They have like a manual, on what terminology they use. Let me give you an example. Attorney fees. Is it attorney fees, or is it attorney's fees, or is it attorney's fee? Depending on how people term particular phrases, you may come up with completely different search results. So you'll find yourself researching multiple versions or variations of a similar concept to make sure that you're being thorough. Okay, so just remember these special issues when you're doing legal research. All right. Okay, moving on. Okay, so now that we have figured out how to go about doing effective legal research, I want to walk you through the second half of this seminar, which is how to actually get to a place where you're delivering a useful product. All right, effective legal research and analysis is a memo, usually a memo. Rarely do attorneys want verbal reports. They might say, just talk to me about it for a couple minutes, but they will also want a memo of some kind. So an effective legal research analysis will provide the reader with pertinent facts or law. It will exclude irrelevant information, irrelevant content, and it will provide a synthesis of the legal principles through meaningful and thoughtful analysis. So what you're really looking for is pare away all the crap that nobody cares about, the facts that no one cares about, the legal issues that nobody cares about. You want to be responsive. This is completely different to the way you're taught in law school and you're taught for purposes of the bar. I teach bar prep courses too, and it's a completely different way of answering questions. When you're studying for the bar and answering questions for the bar, you want to show the bar examiners about how much law you know, and it often involves talking extensively about things that have little to no relevance to the actual legal question. For purposes of legal research in a professional, high-paced, fast-paced, complex lit, large law firm setting or small law firm setting, the focus is going to be on providing an answer, and the answer has to be brief, it has to be succinct, to the point, right, and then it can contain more detailed and deeper language later on if the reader really wants to get into the nuts and bolts and learn about all the background of why the answer is what it is. Okay, and to do that, it requires thought, planning, and effective legal research and analysis on your part. All right, so in terms of legal research methods, how do you get to, providing useful, effective legal research? You should follow the assigning attorney or practice group's directions or habits first. Okay, so if you are working with a very particular personality who has a very particular way of doing things, obviously you should follow that person. On the other hand, if you have not worked with that person well enough to know all their pet peeves and desires, then using this default system I'm about to tell you about will help you. I mean, it'll help you establish a baseline for turning legal research into a written product. These are suggestions only. Over time, you are going to have your own style. You're going to have your own way of writing and researching that is going to depend on your individual strengths and things that you want to do and things that you don't want to do. Okay, but this is just if you're not at that point yet where you have the drill down, this will give you a place to start. All right. So, as we talked about, by the way, this I just refer to as a 2-pass method. You do 2 passes at the legal research memo, and then that'll get you to a place where you're ready to turn it in. All right. So you've developed a plan. That's what we were talking about up to this point in time. So once you've got your plan, you're going to develop a rough outline. So before you start researching, frame your questions. All right. Write on the piece of paper. Actually, you're not going to be writing it down. You'll be typing it. But type out on your memo document what issues you're going to be looking at, because staying organized and keeping track of what you're going to be looking at and having like a roadmap of where you're going to be looking, it will help you figure out where you need to look, where you've already looked, and where you shouldn't be looking. Let me give you an example. You know those people who find gold in Alaska? I don't know if you've ever seen documentaries on those. The people that look for gold up in Alaska, which can be mountainous, it can be, very unhospitable territory, they don't just show up there and start looking. They have like these very detailed maps, and their maps are not only of the topography, but they're maps like, they use the special equipment that will tell them how deep below the, surface of the ground there's gold. So it's the same kind of thing. I mean, You've got to know the lay of the land before you're going to be very effective in providing legal research. So start off with an outline of what you're going to be looking at. Then you are going to do the legal research. You're going to make your first pass at researching whatever it is that you think you need to be looking at. After you do that, you're going to write it up. So you're going to do legal research in one pass. You're going to do writing up what you found in another pass. Sometimes associates make the mistake of reading everything first, saying, I just want to kind of figure out what's going on before I, delve into it. And unfortunately, you'll spend twice the time doing it. What you've got to do is read a case, and as you're reading it, what tends to be effective is just cut and pasting the sections that you think are relevant. And if you cut and paste from the cases that you're reading, and as you're cutting and pasting, make sure to include information about the specific page numbers and what the specific sites are. What you should end up with after you've done the legal research is a series of blurbs, like a bunch of paragraphs that contain the language. And then, so you're going to have all that on your Word document, and it's going to include some references to the case name, case number, page, all the citation stuff. So after you do that, you're going to end up with literally a document of little paragraphs. You are then going to synthesize all that, and by the word synthesize, I just mean you're going to make sense of it and digest it and put it together as though you were going to explain it to someone who had no idea about what you've just done. That is going to result in your write-up, all right? And so after you've done that, you should at that point have a memorandum of some sort that is written up. It's no longer just a series of paragraph blurbs. It's now, in normal English. And from there, once you read it, you're going to realize that you've got some gaps in your research. Like, not every concept flows from one inferential point to another. You're going to almost always you will have gaps. Once you've identified what those gaps are, you'll make another list of them, and you'll say, I need to look into XYZ. These are also the questions that are going to come up in your mind as you're researching. It is very normal during the course of legal research to have questions come up about issues that you are wondering about in your own mind. It's very normal for this to happen. However, you've got to keep track of them when they come up. If you don't write them down, you'll forget about them. And then you can include them in the second round of research you do. So you'll be researching once, writing it, and as you're researching, you're going to cut and paste sections of those cases that are relevant. Then you're going to end up with a page that has the blurbs on them. You're going to take those blurbs and you're going to turn them into a written product. Then you're going to identify what gaps exist in the research trails. Then you're going to go back into the researching game, research what you need to research, find what you need, and then work it back into your document. That should be the end of the legal research. From that point, you can work on editing the content of your memo to make it read right and sound right and be spelled correctly and all that stuff. It's possible later on that you might find other gaps that you've got to fill, but if you do it right, you should only have to do this twice. All right? Okay, why even have a method to doing this? Let me just say, keeping new concepts straight can be just overwhelming, especially if you're doing research in an area of law that you're not entirely familiar with. You could, you aren't going to know what's relevant and what's not relevant. And because you don't have the time and because the client doesn't have the money for you to become fully educated on this, you're really doing the best you can. You know, some associates characterize it like running with scissors. You know, you're just doing the best you can to get as much information and make as much sense of it as you can in the amount of time that you have before, you know, someone will look at you as though you're just wasting time going on a researching adventure that is leading to nowhere. You should also try to do research in the same sitting, and it shouldn't be more than a couple of hours straight. If you research over a period of 1 to 2 days, 2 to 3 days, 3 to 5 days, or longer than a week, you're going to end up spending a bunch of time on it that is not efficient, because there are transaction costs in mentally by starting and stopping the kind of work that you're doing. If you start doing one thing and then you get distracted with some other stuff, it's going to take you 15 to 20 minutes to get back to where you were in the last setting. So you've got to just try to make enough time for it in a day that you've got the time, get it done, and then leave it alone. If you find yourself researching for more than an hour and a half to 2 hours straight on a single issue, you should stop, because it's a sign that something is not going right. There may be something unusual that you've encountered. So I would say if you're at that length, stop, go back to the lawyer who's assigned the project and tell them about what you've been looking. Ask them for tips on where you should be looking, and then get back to doing what you're doing. All right. I mean, the last thing you want is to be researching for a bunch of time and then have the lawyer go, oh, shoot, I can't believe so-and-so spent this much time on it and didn't see me. Now I won't be able to bill it. And the whole billing thing, it affects associates because obviously your hours get written off, and it affects your realization ratio. On the partner side, it affects them because they get dinged too for writing off too much time. Because the firm looks at them like, why are you cutting down income earning potential of associates? So the best way to avoid all this is to kind of avoid the time ever getting spent to begin with. That is unnecessary. All right, so the two-pass system is intended to centralize your research time. It's supposed to avoid research sprawl, spinning wheels, and keep your focused researched. If you do it right, you should be able to avoid substantial time spent on Westless Lexaw. When you're working with your sources, again, consider the purpose. And also think about whether it's going to take you longer to be researching through books versus electronic sources. If you know what you're looking for, it's probably going to be faster for you to do electronic searches with electronically available materials rather than the time spent reading through books and print resources. Okay? So, obviously the overarching goal of all this is to have the most accurate and complete legal research performed as efficiently and cost effectively as possible. Obviously, you don't want to sacrifice quality for economical reasons, but in some instances, obviously, it's going to be unjustifiable for you to disregard how much costs and fees you're going to take for the convenience factor of performing it faster, doing it electronically rather than using print sources. Okay? So let's dig in a little bit further into the first pass of legal research. So your first pass in researching Westlaw or Lexis is going to be pretty broad. It's going to be based on your plan that you've developed. If you get over 100 results or over 100 hits, then the search terms you've been using are too broad. You've got to narrow it down. What you're looking for is between 20 to 50 cases that stand for whatever proposition that you're looking to explore further. If it's more than that, it's not going to be doable. It's going to take way too much time to read through everything. So go back and revisit the plan if you're getting more than 100 results. Once you've got your search hit list, you're going to be skimming the cases to identify them as relevant or irrelevant. Sometimes what people do is they open up new windows in their browser when they find a new relevant case. They'll like right-click it, open it up as a new tab. And if you do that, then at the end of the skimming through your search results, you have probably like 10 to 15 cases that are relevant. Those are the ones that you can email to yourself or copy paste into a Word document so that you can cut and paste from that and dump into your legal research memo. All right, so once you've gotten the cases that you're going to be focusing on, then you've got the blurbs of what the relevant portions are of each case. What you're going to do is read through everything. Your focused reading is going to be done at once. You should not generally read the cases and, just kind of highlight them and then say to yourself, okay, I'll go back and like reread them and redo the highlighting. It's going to take way too much time. It'll take double the time. You've got to do it in one sitting. So take the case that you think is relevant, make your highlights, make your notes, make your markups. As you're reviewing it, write up the pertinent portions of it. And the pertinent portions are usually going to be the facts, the analysis, and the holding. And at what stage of the procedural posture of the litigation the decision was decided. So do that with each case, and it will help shape the remainder of your research because you'll be able to compare how different cases are, what the relevant inquiries are by the judges, and this will lead you to be able to distinguish one case from the other. If you don't find anything helpful, stop, revisit the plan. It could be an indicator that something's gone wrong. Your second pass, you're going to be looking to fill in gaps and holes. You're going to be reading to find logical flowing propositions from one point to the next. I'm sorry to use the kitchen reference again, but it makes the point. You can't start sauteing your garlic unless you have peeled it. You can't peel it unless you've washed it. You can't wash it unless you've separated it from the clump of garlic bulbs. Everything leads from one thing to the next. If you go out of order, your dish is gonna taste bad. Same thing for legal research. You've got to start at the very beginning, and you've got to go from one flowing proposition to the other. You can't leap and leap over logic. It's not going to make any sense. You do have the opportunity usually through Lexis and Westlaw to go through legal research trails at no charge. So if you've done legal research, usually Lexis and Westlaw will allow you to repeat that same research without recharging you. So you should not have to do brand new searches. You should just be able to go and look through what you've already done to fill in most of the gaps in logic. However, you can do legal research more as you need to strengthen propositions that need a little bit more legal support behind them, or ensure that there's sufficient judicial authority that backs each point you're making. Finally, you're going to have your second pass write-up. You're going to fill in all your remaining points of discussion. You're going to work on revising it, putting your transitions, making sure that everything flows, that you've got the right legal authority, finalize all the citations. Every citation should be accurate. California manual, style manual if you're in state court, Blue Book if you're in federal court. Pin cites everywhere. Don't skip them. One thing that is really effective is if you're making a point, make the point, cite it, and then within that citation do a parenthetical reference that makes the same point. It just doubles the amount of authority it seems to have. And then the last step will be just revising your document until it meets your standards for a completed product. Some people revise a couple times, some people revise to death. That's your preference based on the amount of time that you have. Okay? All right, so in terms of managing what authority you should be doing and using, precedential authority only should be used. You could use persuasive authority that is not entirely on point. It might be helpful. It's often of very little practical use. For federal research, don't forget ERIE, meaning state substantive law questions default to state law. You're not necessarily going to have federal cases that originate from California courts that deal with California legal issues. Also, it's very important to note that you should really, really stay away from ALRs, national sources, other cases that are not helpful, ineffective. Yes, it could be helpful unless you're practicing in an area that really is groundbreaking, like privacy litigation, where there isn't a very well-developed body of law and cases do look to other states for authority. It might be okay, but again, California is kind of at the forefront of a lot of the new and interesting litigation in the country. So maybe there's a New York case, maybe a Massachusetts case, maybe there's some case somewhere in the country that is useful to your facts of your case, but does not arise out of California courts. But again, use that stuff sparingly. It really has no authority. And of course, don't forget to ignore any decision that's marked not for publication, because you'll get in trouble for using it. All right. Digesting pertinent authority. So let's say you find a case that is on point. Obviously, you want to read the procedural posture and figure out at what stage the decision is being rendered, on demur, on MSJ, trial, post-trial, appeal. Facts are the facts. The outcome of the case is absolutely critical. There are times when attorneys mistakenly rely on cases where the outcome of the case is actually contrary to what they're arguing. By outcome, I mean, did the case actually go the way you're arguing? Cases can have really, really good discussions of law, but in the end not be ruled in the favor of your client's counterpart in that case. So you just have to read the case. You can't stop reading at just the head notes. Also, I should mention that Westlaw and Lexis can be incorrect in terms of the head notes. They don't always summarize things correctly, and they also change over time. So, and these are also not concepts that are captured by Westlaw Lexis head notes. So you got to read the whole case. Got to make sure that the outcome matches up with what you're actually arguing. Statutes and laws, you've got to read them in terms of the authority. And again, be mindful of changes over time. Great example is personal jurisdiction analysis. The terminology, the doctrines, the concepts have changed over time. The muscle test, nerve center test, these terms didn't exist, 25 or 100 years ago. Okay, so remember to synthesize all your applicable sources. You might find that there's some political influence as to why things are being decided the way they're being decided. Sometimes there's legislation that is intended to respond to a particular case. Lexis and Westlaw do not tell you these things. It's up to you to kind of really hunt down rabbits down the bunny trails and make sure they're all in the same little cage before you take count and inventory of them. All right, same thing with regulations. Let's talk about the write-ups. Every write-up does not need to be a full-blown memorandum. I don't know if you guys look at corporate counsel surveys through ACC, Association of Corporate Counsel, but every once in a while they have results from surveys of corporate counsel, in-house lawyers, and at the top of the list every single year they do this, of their pet peeves are useless long memos that are ineffective and don't answer the question and explore all kinds of issues that are totally irrelevant. You don't need to write a largely irrelevant memo that, you know, is comprehensive, that spends like a paragraph answering the question and then spends 20 pages talking about other things. That's the law review method. The law review method is not the real world method of handling legal issues. The in-house counsel is just going to get upset about it. They're going to feel like you're wasting their time or money or churning. And so you just need to be effective and responsive. And if there really is an issue to go into depth about, then go into depth about it. You know, there's nothing wrong with that, but it just has to be appropriate for the kind of project you've got. All right. And also, every firm has a document repository, whether it's Elite, DM5, some other, you know, what's the other one, Docs Open, where, you know, you keep track of all the memos that people have done. You can do searches for language so that you're not recreating the wheel and borrowing from other people's work product. Certainly is a starting point, and then you could just update that work. All right. Okay, so default tips for write-ups. Err on the side of citing. The problem with citing isn't getting rid of them. It's very easy to delete them. The problem is that rarely are things cited enough. So every legal point you make should be cited to something. If it's a point you're making, it should have a citation, whether it's case law, statute, regulatory, it doesn't matter. But the only things that shouldn't have cites are facts if you're working with general facts. On the other hand, if you're doing a memo in anticipation for an MSJ, then you might want to put in your facts because you're going to have to put up evidence for those facts anyway in your separate statements and in your statement of the facts or undisputed material facts. Default to crack, not IRAC. IRAC is when you start off with the issue. It can be a little too law school-y. You want to start with crack, which in the opening sentence answers the question. So let me give you an example. Let's go back to the independent contractor analysis. Your opening sentence in a memo, you know, at the top should have a summary section. It should say, in this case, based on the judicial authority and investigation that has been performed, employee XYZ will most likely be found to be an independent contractor. As discussed for the reasons more fully set forth below, it's because XYZ. And that would just be your little summary. And then in the sections below, you would then drill down into each and every point. That way the reader doesn't have to read the whole thing in order to figure out where you're going with it. When I was a young lawyer, I was horrified that, you know, the people that I worked with said the same things to me. They're like, nobody's going to want to read your 20-page memo. And I didn't believe them, and my reaction to them was, well, how could we possibly work and live in a profession where all we do is read, and yet you're telling me that the smartest people who are going to be reading don't have the patience or time to be reading this memo that I spent so much time to prepare that contains all these answers. It's not just the partners who don't have the time to read it. The judges really don't have the time to read. I mean, they may have, you know, 15 minutes to a half hour to read briefs from both sides and come up with a decision and figure out how they're going to write up the memo to the judge or the opinion that the judge is going to enter on it. And so there's just not a lot of time to really be pondering, you know, things in a memo. It's got to be right up to the point. It's got to be succinct. It's got to contain no fluff and really get to the heart of what the issue is. Persuasively, of course, and again, if there is an issue that really does merit the time, then you've got to include it. But one of the key ways of doing that is to have crack in there, which is including a conclusion at the beginning and then going into rule analysis and repeating your conclusion again, rather than just kind of starting off with no map of where you're going. In the words of somebody important that said this to one of us and many of us, tell people what you're going to be saying to them, say what you're going to say to them, and then repeat what you just said to them. So again, tell people what you're going to be talking about, talk about it, and then tell them again what you have just talked about. And that keeps people focused on what your point is. So keeping your purpose in mind, give answers, direction, advocate, don't ruminate, know when to focus on the law and not just facts or analysis, and then use memos as an opportunity to highlight good judgment, good recommendation, strategy. I mean, that's what law firms are looking for. They're looking for associates that are thoughtful lawyers, not batteries. Okay? All right, so this takes us to the end of the presentation. We've got about 15 minutes for questions. So for anyone who is listening to this live, please feel free to send an email or use the chat function to send in your question, and I'll be happy to answer them. Okay, so the first question we've got is, the problem I have is that the partner I work for seems to change the assignment a little every time I go back with the answer. I constantly feel like I'm not giving the right response, but the questions seem like they keep changing. What can I do about this? Okay, this isn't unusual. The problem is that assigning attorneys don't always know what the answer is, you know, and it's like, again, that same graphic with the ocean where nobody can see below the surface. They don't know the answer, and when you go back and do some research and find the answer, it can kind of change the question and change the assignment. The way I found to get around this is to make sure you've got some sort of a written back and forth confirming what the assignment is. Because here's what tends to happen. You get an assignment, you do the research based on what you understand as the assignment, you turn it in, and the partner's like, you didn't give me what I needed. And then on your review that year, they're like, doesn't follow instructions and doesn't give the product for the question being answered. The way to fix that and protect yourself is, you know, when you get an assignment, just send an email back saying, this is my understanding of what I'm doing. I just want to make sure I'm researching the right thing. Does this sound right to you? And that way, at least you've got some sort of a paper trail on, you know, what you're being asked to do and your understanding of what you're being asked to do. And if there's a disconnect there, at least you can clear it up at that stage rather than 4 or 5 hours into the project. So that's my recommendation on that issue. Okay, another question. Can you talk again about how you cut and paste out of cases before doing a write-up? Sure. Okay, so you've done your Westlaw or Lexis search. It has turned up 20 cases, okay? And you're probably going to open up a new tab for each case or print out each case. But either way, you're going to get to a place where you're reading through cases. As you read through them, cut and paste the portions that seem relevant to your legal issue. And when you cut a paragraph, put the citation in right below that cut and paste paragraph. So at all points in time, you'll have the case name and pin site that goes with the paragraph you've cut and pasted. Once you get done doing that with all your cases, then you should have a series of legal principles that you will then synthesize. Some of the cases will go through the same points, you know, in the same order or in a slightly different order. What you want to do is synthesize everything, meaning digest it all and turn that into a legal analysis paragraph that walks through the legal points one point after another. The reason why this cut and paste way of doing it works so well is because it really cuts down the amount of time you spend reading cases. As I said, if you read cases once, I promise you by the time you start on the second case, you will have forgotten what the first case was entirely about. And if you're doing this for hour after hour, reading through 20 or 30 cases, you're just not going to remember. You're not going to remember what the cases say. And the other thing that is hard to do is keep in order what cases change the law in what order. A lot of legal issues, in the ones that matter and count, the law is developed over time. So you might have a case decided in the 60s, and then in the 70s there's a modification, in the 80s there's a change, in the 90s there might be more added to it. And the problem is you might find 20 cases, and then let's say you print them out and you put them in order by year. You may have missed a few cases, and by the time you realize it, you will have forgotten all about how the law changed because you'll be trying to figure out where to put that case in your long line of cases. So my strong suggestion to you is analyze while you are reading. Do not read and then say, I'll analyze the cases later. Do it in one pass. You'll save yourself a ton of time. All right. Question. One of the comments I hear a lot is that my good points are buried too deep in a memo. How do I fix this? This is a common issue that comes up. It happens because young lawyers are logical. This is a sign that you're a logical thinker. You want to go through things one at a time from beginning to finish. Unfortunately, the reality of the legal practice and litigation is not logical. It's not chronological. It's in order of priority, okay? So as you're doing legal research, you're going to come across issues that are going to be make it or break it issues, all right? And you have got to know what issues are make it or break it issues or showstopper issues, because if you have a showstopper issue, it's pointless going into the minor, less important details or facts, because you know you can't get around the big issue. All right, let me give you an example. Let's go back to the independent contractor example that we've been using. If you have a situation where the independent contractor has signed an agreement with the employee saying, I agree that I'm going to be an independent contractor, I'm not an employee, I agree that I'll be paid on a 1099 basis, I'll agree that I'll submit invoices for payment of my services. If you've got such weight on one big factor, it is pointless to put that at the end of your memo. That should be at the very beginning, because it's dispositive. It doesn't matter so much if the contractor used his or her own equipment, or if the contractor worked 9 to 5 or 10 to 7 or whatever, or if they, worked off-site or on-site. If one of the factors you're analyzing has a ton of weight on it that is really important and it'll change the analysis, then you've got to talk about that first, and you've got to prioritize all of the other elements that you're looking at to make sure that everything's from order of importance, from most important to least important. Obviously, there's going to be situations and times when there's relationships between elements, like you can't get to point A without point B without talking about point A first, and that's fine. But generally, you should order and structure your memo so that you're tackling the most important things first. Otherwise, whoever's reading it is going to be like, why are you wasting my time, talking about minutiae when there's really, really important things to talk about. All right. Any other questions, comments? Please feel free to email or use the chat function. Okay. Says the partner I work with says my writing is too flowery and not straight to the point. I feel like I'm dumbing down my writing by writing in simple sentences. He says that when I write normally, it's too much like I'm writing a novel. Do I really need to change how I write? The answer, I hate to say it, is yes. I was the same. When I first started out, I wrote way too complicated, complex, spent way too much time on, writing. As I said, when you're in law school, college, growing up, you're taught to have this very overdeveloped, flowery sense of writing. And when you look at the way briefs are written in court, even by lawyers that have been doing this for 30 years or very high-profile lawyers, you're always struck by how overly simplistic it is and how simple and straightforward the language seems to be. There's a reason for it. When you're writing in legal writing, you are not writing to impress anybody. You're not writing to show how clever you are. You're not writing to show how great of a vocabulary you have. You're not writing to impress anybody. The only thing you're writing about is to convey information. And, imagine if you know what a great example is? Imagine if you're giving instructions to a car that's pulled up next to you and it says, hey, can you roll down your window? I have a question about how to get to somewhere. If someone on the street is asking you in the moments that you have while the light is still red, hey, can you tell me how to get to, Wilshire and whatever, you're not going to be like, well, sir, you're not going to be speaking in poetic, flowery language. You're going to say, take a left, turn around, make a right, and you'll get to where you're going. That's what legal writing really is. Judges do not have the time to read beautifully, meticulously put together, mellifluous, beautiful prose that you might have spent hours and hours putting together. They just want to know what you have to say and why you think you're right, because they have thousands of other cases. I mean, the PI courts in downtown Stanley Mosque in Los Angeles County, you're looking at 25,000 cases between 3 courts. They just don't have the time or the energy or the desire to pick through very, flowery writing. So I'm sorry to say it, but yes, you've got to cut down the flowery writing, and you don't need adjectives, you don't need adverbs. It should just be very straightforward. You don't even need that many transitions. It should just be very simple, point to point, and you're not dumbed down by writing that way. It's just how legal writing is. It's very straightforward and very to the point. Okay, seeing nothing else coming through, I just want to, let me just read to you a couple of the last instructions. So the two codes again, in case you missed them, let me see if I can find them. The first one was 25981, and the second code was 84547. You will get an email, or maybe you already have the email, with the link to requesting California MCLE credit. It'll ask you for those two codes. Please input them, and then the Blueprint Legal people will send you your certificate of completion. For anyone who's listening to the seminar on demand, online, through a webinar, if you do have questions, you can feel free to email me. I think my contact information is somewhere. If you like it, I'm happy to help you or answer any questions you might have. Otherwise, thanks very much, everybody, for their time, and hope to see you again sometime soon. Thanks again.